Okay. I think that is probably as much as I need to say, other than I really want to thank Darren for joining us today. Darren is the senior policy executive from the Australian Human Rights Commission, and he's going to be providing to us today with a brief on the inquiry in the Australian Human Rights Commission model for an Australian Human Rights Act. So he's got some information to share with us. There's also going to be opportunity for you to ask questions and some discussion points that we might have towards the end. And QCOS has a few questions for you as well, to help us be representative in the views that we share through this process. So lots of opportunity to have a say as we get towards the end of the session, and happy for you to use the chat to engage in that. Okay, that's enough from me. I'm going to hand over to you, Darren. Thanks very much. Now, I can hear that someone's not on mute, so I'm just going to ask if everyone can just make sure that they are on mute as we go through the session so that we can hear. Thanks very much, Darren. Over to you.
Thanks, Stacey. First of all, I am coming from Gadigal land down here in Sydney, and pay my respects to the Eora people and to their elders past, present and emerging as well. And thanks for the opportunity for us to provide this briefing for you. As background, the Commission has been doing a project over the past 3.5 years called Free and Equal, and the starting point for that project was, what should our national system for protecting human rights in Australia be, and how can we improve the current situation? And we've kind of very slowly moved along with obviously a pandemic in the middle, and a government that wasn't exactly hanging out for our reform proposal over the last couple of years, working our way through some of the really challenging issues about how you improve our human rights system. And we've put out now 2 very substantive pieces, which are position papers setting out our federal discrimination law reform agenda and our proposal for a federal Human Rights Act. What's happened off the back of the Human Rights Act position paper is that the Federal Attorney General has referred to the Parliamentary Joint Committee on Human Rights an inquiry into Australia's human rights framework. Now, the Australian Human Rights Framework was an initiative that commenced under the Rudd government, which was essentially what the name says, a national framework for human rights, setting up what is the federal approach to protecting human rights. And the inquiry's reviewing the effectiveness of that framework that existed from 2010, and National Action Plan on Human Rights that was also introduced at the time, and then considering whether a framework should be re-established, what its components should be, what improvements should be made to it. And in the context of that, what they've also got as part of their terms of reference is whether the Australian Parliament should enact a Federal Human Rights Act, and if so, what elements it should include, including by reference to the Australian Human Rights Commission's recent position paper with the Model Human Rights Act. So the Model Human Rights Act we've got is quite central to this inquiry. And so what I'm going to do in this is we'll do you a presentation that takes you through the Commission's Human Rights Act model, and I'm happy to take questions as we go, or I'll pause for questions and put comments in the chat and those sort of things as well as we go. And then what I want to come back to is also this PJCHR inquiry. And what the Commission's now done is we've also put in a fairly substantial submission to that inquiry. If you look on the PJCHR, as the committee's generally known, look on their website, you'll see it's the first submission made to the inquiry, and in that we propose what a new national framework on human rights should be, which is, a Human Rights Act and other measures. And so I'll talk to you a little bit about that. What we've been doing is we've been doing briefings for different sectors in the community around the Human Rights Act model, and I would estimate we've now briefed about 400 plus separate organisations on the model. Our objective with this is that we obviously think there should be a Federal Human Rights Act. It's been something that's been elusive and difficult to achieve over time. And what we're proposing through the PJCHR inquiry is that what we want to come out of that inquiry is the committee saying, yes, there should be a Human Rights Act, and that the government should take the Commission's model and turn it into a bill, and then have a draft exposure bill, and that we then discuss some of the more technical details at the level of the bill. So what we're trying to achieve with that very much is, if I can use the analogy of a Republican debate, where you may have possibly a majority of Australians who think Australia should be a republic, but what happens whenever the Republic debates happen is there are 7 different models for the Republic, and there's not consensus around a particular model, and so you kind of lose the progress and the momentum towards it. So we don't want disagreements around what should be in the model or out of the model to be the reason we don't get to having a bill on the table to discuss. And for that reason, I mean, we've had extensive consultation in developing this model, where we're sort of suggesting that what community orgs do is that they come in behind the model, even if there are some issues in there where they may want to see us go further on some points or a different nuance. But I must say, I mean, broadly so far, the model is enjoying very broad support, and I think it's quite an exciting model because it frankly goes further than any of the models that exist at the state and territory level. Would expand on what's in the Queensland model, the Vic model, the ACT model, and it has some innovations in it that, if they were introduced, would be world first for Human Rights Act as well, and I'll particularly focus on those. So I'll share the screen and I'll go through PowerPoint, and then, as I said, I'll stop when we get to when I've gone through the model, and then come back to talk about the PJCHR a bit more broadly as well. Hopefully that's up on screen now. So it's my end, it is. So why do we need a Human Rights Act for Australia? We think very simply, the view of the Commission is that people's rights matter all of the time. And what we tend to find in federal processes at times, without having the guidance of a Human Rights Act, the guardrails of a Human Rights Act around which to make decisions, it means that if there are circumstances where it's kind of convenient or easier to adopt approaches that are not human rights compliant, that's what the Parliament has done at times. So we're saying that the impact of laws, policy and practice on people's human rights should always be considered in the federal system, that Parliament, governments and public officials should be held to account for how they consider human rights impacts in their decision making. And the image on the right side there, basically shows the implications of this. The first one being that laws should protect and respect human rights, that when decisions are made, the human rights impacts should be considered. And thirdly, that if those two things are not done, then there should be remedial framework available where human rights have not been considered or where they've been breached without justification. So that's kind of the broad why. And if you look to the position paper we've put out, and there's a summary version of it as well, you'll see there's a number of case studies in there that talk about how, if there had been a Human Rights Act, there would have been better protection of people's rights in a number of areas. Most notably for that, at the federal level, is in relation to some COVID-related issues and the way that the pandemic was managed. People trying to return home from overseas, for example, is a very prominent example. And similarly, robo-debt as well, where, as a Commission, we're fairly strongly of the view that if you had the guidance and the provisions of the Human Rights Act, that the issues that arose in that process may not have arisen or would have been addressed a lot earlier as well, with better protection and remedies for people who were affected. Ultimately, the proposals for a Human Rights Act for the Commission, there's a conceptual framing of how we've gone about this work, and in fact all of the work around a new national human rights framework that I'll talk about later. And the conceptual framing is that what we want to see is a better consideration of human rights in the upstream. And so by upstream, we mean that it's done at the beginning of the policy development process. It's not done as a consequence later on when a right's been breached, and then people start to think about it or to justify why it's appropriate that they've done so, etc. And in a preventative manner. as well. So for us, that sort of upstream consideration will come through a range of different mechanisms with a Human Rights Act. It comes through an improved focus on statements of compatibility with human rights, and that accompanying all legislative instruments, bills and delegated legislation. It comes through a more focused assessment of the human rights impacts through Parliament. It comes through public servants having a duty upon them to consider human rights and to ensure the participation of people who are affected by the decisions, by the training processes that are put in place, etc. But what we see really is probably one of the fundamental challenges at the moment at the federal level is that you can aspire to have these upstream considerations, and you have a lot of the key elements for this upstream consideration already in place, like a Parliamentary Joint Committee on Human Rights, for example. But what's lacking is the downstream. So what we describe as the downstream is the remedial framework. It's the ability to have the decisions reviewed in terms of their consistency with human rights, to bring your complaint to the Human Rights Commission or through the federal court system. And we don't actually think that when it's in place, that most of the action that will take place under a Human Rights Act will be through the complaint streams and through the judicial processes. They're almost a bit of a fallback, really. We think the action will happen in the upstream side of things, but it will happen because there's a consequence if you don't do it. And at the moment, it's a system that doesn't have the checks and balances in place. So, for example, the Human Rights Commission, we operate under the Australian Human Rights Commission Act. There's a stream of complaints under that legislation where people can bring complaints to the Commission about breaches of a number of international instruments, including the ICCPR, the Civil and Political Rights Covenant. We had, I think, 700 plus complaints during the COVID period about people trapped overseas who were unable to return home. A lot of those stories of people were quite heartbreaking. They were people who were looking to return to be able to visit dying relatives who had emergency health conditions and needed to come back to Australia for emergency health treatment, etc. And there was essentially very poor response from government to these situations. And people could bring a complaint to the Commission, but the complaint process under that Act, the way it operates, is that we attempt to conciliate with the federal government. Well, in most instances, there just wasn't a desire on the behalf of government to do that. And then that's it. Basically, we can report to the government and they can decide whether to publish that report in Parliament or not. But that's kind of the end of the process. And so there's less engagement in that process because it doesn't have the downstream mechanisms and protections that would compel or encourage government to participate in the process, because they know there's no consequence if they don't. So the Human Rights Act provides that downstream protection, which can mean that you can get that more effective understanding and engagement with rights from the get-go rather than as an add-on at the end. So that's fundamental to this model. What we're proposing in the Federal Human Rights Act would be the broadest protection of human rights in any Human Rights Act in Australia. It's the full range of civil, political and economic, social and cultural rights. So picked across both of those key covenants that Australia is a signatory to and that has been a signatory to since the 1970s. Probably notable in this, there's two features, or three features that are notable in this model. There's probably more than three, but I'll talk to three. The first, which you can see on the bottom rung, the bottom right of the list of rights here, is a right to a healthy environment. There are in a number of the rights internationally in the treaties, there are a number of provisions that relate to environmental health. That what we've done is we've drawn them together and decided that they should be reflected in a treaty, in a Human Rights Act as its own standalone right, rather than something that's implied through a right to health or other such provisions. And so we've included that right to a healthy environment as one of the rights that would be actionable under our model. The second feature is around the cultural rights of First Nations peoples, which is also explicitly included, consistent with Articles 27 of the ICCPR and Article 30 of the Convention on the Rights of the Child, as well as many other supporting rights as well. And then the third feature is that the model includes all economic, social, cultural rights that are in the ICESCA. What we've done with these rights is you may be aware that at times there are conversations about whether these rights are justiciable, whether they're sufficiently defined, whether they, by asking the court, if the courts had a role in interpreting them, they would be raising constitutional issues about separation of powers and those types of issues. So we've crafted the scope of these rights very carefully. Includes the core and the minimum and the sort of essential requirements for each of these rights. What we've said is that the elements of those rights that are progressively realisable, it's under the progressive realisation principle that applies to ESC rights, would not be justiciable. So there is some limitation that's been built in there. And we see that progressive realisation principle would get addressed for a broader range of measures that are in a national human rights framework, and that judicial resolution is not the appropriate place for that. So there's some limitation there on the scope of the rights, but as I said, it would still be the most comprehensive set of rights that are recognised in a Human Rights Act in Australia. And we're confident that what it would do is provide a significant additional protections across the community, and that we will be able to address those progressive realisation issues in other ways. The two core features of the Human Rights Act really are how people are able to bring actions under them, so cause of action, and the duties that would exist on public officials to comply with the Human Rights Act. So this slide talks to the duties, and this is what I alluded to at the beginning around some of the world first provisions that are included in the model that the Commission has developed. So most Human Rights Act globally, and certainly all the Australian models, include this, what's in the green text on this slide, which is a positive duty to act compatibly with human rights and to give proper consideration to human rights in making decisions. So there's a general duty that exists under the Queensland, Victorian ACT duty to this effect. And it is something that in considering whether there's breaches of rights, you're able to consider whether this positive duty was met or not by public servants. It puts a much stronger requirement upon public officials as to how they must consider rights in this model. And we've adopted very much the standard version of that's existed in these models domestically, as well as in international comparative models like the UK and New Zealand and so forth. But what we've included are the two additional duties, which are on the right side of the screen: a participation duty and an equal access to justice duty. So a participation duty we have specifically tied to three particular groups in the community, which reflects the specific treaty obligations that Australia has under human rights treaties. So those groups are people with disabilities under the Convention on the Rights of Persons with Disabilities, children under the Convention on the Rights of Children, and Indigenous peoples. And for Indigenous peoples, we're looking at a direct implementation of Articles 18 and 19 of the Declaration on the Rights of Indigenous Peoples. That is, of course, a declaration, not a treaty, for those the technical wonks among you. And so it also is referable back to multiple treaty obligations that Australia has under the Racial Discrimination Convention, the Civil and Political Rights Convention, and others as well. So we think these are very soundly grounded in our international treaty obligations. And essentially what this participation duty does is it acknowledges that what we would say is probably the key failure to protect rights in the federal sphere over the last 10 to 20 years has been policies that are developed and laws that are designed without the effective participation of the groups who are particularly impacted by those laws. That is undoubtedly the impact on Indigenous peoples. It's largely why we're having this referendum on the voice at this point as well. So the way this duty would operate is at both a group and an individual level. So if you take the situation of persons with disability, it would be a requirement that supported decision-making processes are in place for decisions that are made about people with disability at an individual level. For example, in relation to children, similarly, that the voices of children are heard in any decisions that affect them, and that's a right that is described as being subject to the evolving capacity of the child. So obviously the ability of a 17-year-old to participate in a decision that's significantly going to impact their life will be different to the capacity of a 6-year-old. So there's some sort of, there's a spectrum of participation that's already acknowledged within the international system. And for Indigenous peoples too, it's about ensuring their effective participation in decisions that affect them. What we've done in the position paper is we've set out a set of principles that would assist in understanding how this participation duty would operate in practice, and that draws off international guidance around participation, various standards that exist around the world, such as the AHRC principles from the European Union and the Gunning principles in the UK, and free, prior, informed consent principles in relation to the Declaration on the Rights of Indigenous Peoples. So to give two examples of how it might operate practically in different circumstances, if the government was contemplating building a nuclear waste dump in an Aboriginal community, for example, the participation standard would include assessing the proximity of the issue to the people who are being consulted. So you wouldn't be able to consult a national voice and say you had consulted Indigenous people. In that instance, you would have to be consulting the people who live in the community who are going to be directly affected, because they are the people who have the proximity to the impact that will arise from any decision that's made. If the policy, the consultation, the law was a broader one around social security reform, then again, you may be required to directly consult with those communities who would be directly affected by that if it's targeted to particular regions of Australia, for example. But you would also anticipate that there would be a role for sort of national representative bodies, peak bodies and others to be consulted in that regard. So what we're sort of proposing with that duty is that it would impact in a number of ways. The first way is it would act as the positive duty generally, the general positive duty in the Human Rights Act operates. If somebody brings a claim that their rights have been breached, they could also bring a claim that the positive duty for the participation had not been met by the government as well, and it would attach to any claim that they would bring forward. But secondly, and prior to that, what we've also proposed is to replicate a process that happens in Victoria in relation to regulatory impact statements. And the regulatory impact statements do have a consultation element involved in them. And if there are affected groups who are unable to, who are not sufficiently consulted in that process, they can bring that effectively as a complaint through to the Scrutiny Committee, the SARC Committee in the Victorian Parliament, for them to consider as they're considering the adequacy of the regulatory impact statement. So what we would do under this model is that if you had Indigenous groups who felt that they were not adequately consulted, and they should be, they would be able to bring that through to the Parliamentary Joint Committee on Human Rights as it was doing its assessment of a proposed law to determine the adequacy of whether this participation standard's been met or not. The second additional standard there is an equal access to justice duty. It's framed as an equal access to justice rather than an access to justice duty, which places a limitation on it. It's not an open-ended duty. But in essence, this is our way of elevating a whole range of procedural fairness requirements in civil and criminal matters, mostly before the courts, but also in tribunals and other decision-making forums. So this would be about ensuring that people have the ability to be able to have access to justice in a manner that's equitable to other people. This might mean reasonable adjustments for people with a disability. It might mean new interpreters, translators, or a base level of legal assistance for others as well. So we think that is also another significant elevation of the protections that exist and that would exist across a range of different decision-making forums. So these are quite, we're quite proud of these as options, and we think they would have a lot of work to do in ensuring fairness and access to justice at the federal level. So they're the duties that would apply across the Human Rights Act. And then the other element, as I said, is the cause of action. So you may know that under there's different models in each of the state charter and state and territory charters of rights that exist at the moment. So the Victorian Charter relies on what's called a piggyback mechanism that requires that if you're bringing an administrative review matter or a negligence action or some other matter, you can attach your human rights claim to the other matter that you're bringing. So it's piggybacked off another claim. You can't bring it in its own right. It has to be piggybacked, excuse me. In Queensland, you can go to the Queensland Commission, bring a direct claim to that commission, and it operates very much like the Australian Human Rights Commission Act complaint jurisdiction that I referred to earlier, which is with some limitations on how it can move forward to the courts. And then the ACT scheme has a direct cause of action where people can just bring an action directly in relation to a right, and they have the full range of remedies through the court process. So what we're proposing is that ACT model. It's a no restrictions on how you can bring your cause of action. If your right in the Human Rights Act has been breached, you can bring an action. What we're saying is that ordinarily you would bring it to the Commission, the Australian Human Rights Commission, much as you would bring your discrimination complaint to the Commission. Or if it's an administrative review matter, you would take it to the appropriate administrative review pathway. And then if the matters don't resolve, then they're unsuited to a sort of a conciliation process, etc. You could then move it to the federal court, the Federal Circuit Court. And that would be the pathway. That's the very basic version of it, which is on the screen. And this is the very complicated version of it. We're saying there should be essentially no, what some human rights acts do is they kind of place limitations on the remedial actions, the pathways, the outcomes that can come from these sort of actions. So we're essentially saying that essentially there should be the full range of remedies available to people, whether that's compensation, whether it's sort of monetary damages, whether it's review of decisions and reversal of decisions or whatever it happens to be. And there shouldn't be any sort of specific prescription around what can be considered and what cannot be considered. It should just be within the ordinary jurisdiction of the court as it would be in any other area of the law. And so that's the sort of the pathway that we're proposing. That would be an improvement on most of the models that exist in Australia at the moment. Now, look, there's a range of other kind of more technical sort of issues that I could mention that are specific to the federal constitutional system. That they're quite complex, and it's probably kind of unnecessary in this setting to go through them around issues like declarations and incompatibility and how you define interpretive clauses and justification clauses and all these sort of things. But what's I think the general point out of all of these things is that there's a lot of rabbit holes in the discussion around how a Human Rights Act operates, lots of really detailed legal questions that involve complex issues around constitutional law and administrative law, etc. And we've kind of dived down all these rabbit holes for the last 18 months to 2 years, and we've landed on this model, which we think enjoys a very high degree of support at this point. And so, as I said, what we're proposing to the Parliamentary Joint Committee on Human Rights is that they should accept the need for there to be a Federal Human Rights Act, and they should take the basic model that we've set out here and request government to turn this into a draft exposure bill that then becomes the public consultation on the draft on a Bill of Rights federally. I might stop for a few moments, Stacey, and then see if there are questions or comments to this, and then I'll bring it back to the PJCHR's inquiry around a new national human rights framework, which is kind of this what sits alongside this model.
Great, thank you, Darren. Any comments, clarifying questions before we move on? You must be thoroughly covering everything, Darren.
It's a lot of detail, I know. I appreciate that too.
Okay, we do have Stephanie.
Hi, thank you. Can you hear me okay?
Yeah, we can.
Yep, okay. Darren, I've got a question about the participation duty, and in particular, we're thinking at QPAST about people with a psychosocial disability and how in the proposed model, we can ensure that people with the needs of people with a psychosocial disability, and we're particularly thinking about arbitrarily detained asylum seekers or people who've had their visa revoked and are facing long-term indefinite detention in an environment that we know creates a lot of mental ill health. Is the proposed model a potential avenue to have people who are detained able to provide advice about what are the conditions of their treatment and what are the conditions of their detention that need to be modified in order to not inflict further mental illness? Does that make sense? It's a pretty complicated question. And
I get you. I think there's two elements to it. One is that rights that would be included in the Human Rights Act include humane treatment while deprived of liberty, and also sort of arbitrary detention related issues. So we think a lot of those matters would be able to be dealt with directly through the application of those rights, and you would absolutely apply. There's the interpretive principle in the Human Rights Act would be that you apply these rights consistent with their international understanding and across the full suite of the international treaties, including the Convention on the Rights of Persons with Disabilities. So you would bring a lot of the guidance in there from that. And then, as you said, the participation duty we would apply to persons with disabilities and the supported decision-making principles in Article 18 of that convention as well. And that, again, would absolutely apply to that situation. So I think that would provide two sort of vehicles for how that issue would be able to be addressed. Certainly at the moment, I mean, the Commission, as I said, we have this jurisdiction, we call it the AHRC jurisdiction, the Australian Human Rights Commission Act, where people can bring complaints to us. But as I said, we attempt to conciliate them if they don't resolve, because they're with the Commonwealth, and usually the respondent is the Home Affairs Department, and they don't resolve. We then do reporting and so on. But we do get a lot around the conditions of detention and around the immigration and asylum seeker issues. And I think there are some of this nature as well that come through that setting. So I think what this would do is provide a more effective legal framework for that process, that they do come through the system now, but the framework's not effective in providing them remedies and the way to take it all the way through the whole system. So, yeah, I think it would cover that, and there would be significant pathways.
Great. Thank you. Thanks.
Anything else? Okay. Looks like we can move on, Darren.
Maybe, Stacey, I'll just answer. You'd put a question to me, I think, in email before today as well. It might not have been you, which is about how this might operate for QCOS and organisations who are members of QCOS as well.
Yes, I think that was Lauren, who I will mention is on the line.
Yeah, so why don't I answer that one now as well, because it probably makes more sense there. And so essentially the way, I mean, the scope of the Human Rights Act is that we, first of all, we say it should apply to all people within Australia's territory and all people subject to Australia's jurisdiction. So the issue there is around effective control, which will be around military bases, around offshore detention and other settings we say would apply in those settings. And it would apply in relation to...
unless it was just too much for the system.
Federal laws and federal public authorities. And then the question of how it would apply to, say, the QCOS, etc., would be around grants processes and those sorts of things, and the ability for sort of community organisations to be bound into the Human Rights Act by exercising functions through the federal system. So I suspect the main impact of it for different organisations who are not government entities themselves will come through contracts and through grant processes, much as you have requirements in them at the moment to comply with federal discrimination law and, you know, anti-slavery laws and those sort of things. There'll be a requirement to act consistently with the Human Rights Act, and it will bring some organisations for where they're exercising those federal functions within the scope of the Human Rights Act. But aside from that, it'll operate concurrently with the state legislation where it exists. So it'll operate concurrently with the Queensland Human Rights Act. It won't replace that jurisdiction. And we think the crossover between the two there will be some, but it'll be sort of not massive, I think, but I think there will be some coverage through those, which will come through contracting, procurement. Did anyone have any other questions at the moment, or on?
Thank you. Very thorough so far. Thanks, Darren.
Yeah. All right, I'll move on. So this Parliamentary Joint Committee on Human Rights, I know one person's got their hand up, so if they want to speak.
Joshua.
I can't see who it is, I can just see your hand.
Hi, Joshua. Would you like to ask something?
Hi, thank you. I just wanted to ask a question. Given the Queensland human rights legislation, they sort of suspended that for the new, the strengthening the community bill.
Yeah. So
I'm thinking, right, at a federal level, can they have a safeguard mechanism so they can't do something like that? Or it's got to be scrutinised completely so they don't suspend those kind of state-based human rights legislations?
Yeah, it's a good question. And I mean, the first thing is that this would be affecting federal laws rather than state laws. So it wouldn't operate to sort of override those state laws. Although if it's racially discriminatory, it could through Section 10 of the Racial Discrimination Act, which is a fairly powerful and fairly unique provision across the discrimination laws. But how I think there's a few differences for the federal system. I mean, one difference is obviously the Queensland Parliament is a unicameral Parliament as well, and you don't get the two separate houses of Parliament, and some of the scrutiny processes are probably less rigorous than they would be in a bicameral system. You would expect that you would have much greater scrutiny of decisions than, you know, obviously in Queensland the government controls Parliament, and so if they've made a decision to do something, then the parliamentary committee process is less powerful, and being able to dissent from that and change it that's just a practical issue. But the other thing with this is that I mean that was the first time, obviously in Queensland, that there's been a declaration that the government intends to pass legislation that's inconsistent with human rights. It's, as I understand it, hasn't happened in 20 years in the ACT, and it's very rarely happened in Victoria as well. So those instances are not the norm of the situation. They are exceptional. And while we think those changes were not appropriate, and we wouldn't support them, that's for sure, what we'd also say is that the fact that the government has to actually get up and say, actually, we are suspending the Human Rights Act, or, you know, we are going to pass a law that breaches human rights, creates a very different dialogue about that bill than it might otherwise have been. It might have been purely a law and order issue, and whatever would have been the framing of it. And I think there's been a lot more heat and scrutiny on the government for that decision. And I wonder if they'd do it again in such a way as a result of that. So I think that while it doesn't offer the ultimate protection of invalidating that law, it still places a lot more significant accountability and transparency on government for what they're doing. And we think that's the big cultural shift that you get with the Human Rights Act. And it often, you don't see it. It kind of happens behind the scenes. There's a number of examples in the COVID experience in Victoria, for example, where actions behind the scenes resulted in, a winding back of potential restrictions that were going to be imposed on people. But that's not what's seen in the public domain, because the government knows that it would have to get up and do exactly what they did in Queensland and say, yep, we're suspending human rights protections, or we're going to deliver. We know we are breaching people's human rights, and we are going to go ahead with doing that. So, but yeah, ultimately what we're proposing is a model that this is an ordinary act of Parliament. It sort of retains parliamentary sovereignty. And so, if a government is willful that it is going to breach people's human rights, the existence of a Human Rights Act isn't going to be an absolute bar on that. That is a limitation. But we know in the federal system that the only way that you can guard against that is to have it at a level of the Constitution. And I think we all know how difficult that is to achieve. That maybe it'll happen 20 years from now. You get the Human Rights Act in, and then over time there's community sentiment moves to saying, yes, this should be embedded and it should be constitutional and it should be something that can never be breached. But I don't think that's where the community's at, and nobody's kind of really advocating for a constitutional level Charter of Rights, because we know it's not feasible. Ren has a hand up as well.
Yeah, hi. I've actually got a very similar question in terms of the way the National Human Rights Act might impact jurisdictional legislation, but this is more around compensation for human rights breaches. So last year, the NT government they changed the legislation so that people who were in custody who were claiming compensation rights for human rights breaches had the amount of their compensation was capped at $15,300, and most of that is quarantine for victims of their crimes. So this came off the back of the inquiry into Don Dale Detention Centre and the findings that a number of young people had had their human rights severely breached by government workers, and the government was essentially sued for a large sum of money for compensation for those children who, as many people saw in the Four Corners report, had their human rights extremely breached. And so now there is no real incentive, because people cannot access those compensations anymore. So I'm just wondering, in terms of the complaint process, whether or not a National Human Rights Act would override a legislation like that, or would that still be a state-by-state basis as to whether or not that legislation would override the National Human Rights Act?
Yeah, well, the National Human Rights Act would operate for federal law and federal processes rather than state laws. So the state systems would still it would still operate within a state context. What it might do is mean that it would be more difficult for them to do that at the federal level, for example. So where you had federal prisoners or people who were in immigration would be the obvious place where, if there was a similar sort of fine compensation owed to people, that not being able to do that same sort of thing in terms of the unequal treatment. I mean, the whole space of prisoners' rights is quite a vexed area too, and the restrictions generally on prisoners is significant. And I think one issue that's kind of gone under the radar with the referendum, for example, is that a number of Aboriginal prisoners won't be able to vote in the referendum. I think if you're in prison for a term of more than 2 years or something like that, you're not entitled to vote. So, and that is going to disproportionately impact Indigenous peoples. And it's a shame that hasn't been dealt with as an issue. So Yeah, I think there'd be more profile on those sort of issues. Not sure how effective it would be in addressing it. Certainly wouldn't be able to override the states though, because we've said that essentially every state and territory should have a state charter of rights or human rights protection for themselves that covers state instrumentalities, and then this is for the federal instrumentality. So that would be a state or territory issue. So it wouldn't be covered there. You know, there may be a way of bringing that through discrimination law though, because as I said, Section 10 of the Racial Discrimination Act, which is equal treatment before the law on the basis of race, that provision operates in combination with the Constitution around the inconsistency of laws and federal laws prevailing over state laws to provide a constitutional bar on some issues. So it'd be interesting to see whether that impact, if that's particularly disproportionately impacting Indigenous peoples, was able to be able to brought through the Racial Discrimination Act as a provision that could be challenged. But I'm not sure if there's any challenge coming through in that way at the moment. So that's probably where
I'm just wondering if there would be through the complaints process for the national framework, whether or not there would be a process for them to raise the complaint at a federal level if the jurisdictional level wasn't supportive of them seeing any compensation for those human rights breaches, whether or not there would be a process under the national framework for them to be able to, I guess, elevate that complaint to a national level.
Yeah, not sure. I think we can take that on board and about it. I think it's a significant issue.
Yeah, because I think that's sort of, for a lot of people, especially First Nations people, the question would be, in terms of having a national act and framework, what would be the benefit for them? Because at this stage, a lot of people won't put in a complaint because they don't see any avenue for actually getting any kind of response or compensation for what they've experienced.
Yeah, no, I understand that. Yeah, and that's one of the concerns we have about the mechanisms that exist at the moment under our Human Rights Commission Act too, is that we can identify that there's been a breach of people's rights, that they've been arbitrarily detained, that they've been treated cruelly and inhumanely, and that they're entitled to compensation. And that's the end of it. The recommendation gets made and there's no obligation for government to do anything. So they most often don't. We just think that's unacceptable and needs to shift to a fully accountable system, which we think this would provide. Shall I move up to the next part then? So this is around what a new national human rights framework would be. So essentially what you had when the Labor government came in and whenever they set up the Brennan National Human Rights Consultation, which led to a recommendation that there should be a Federal Human Rights Act. And instead of doing that, the government introduced Australia's Human Rights Framework, which proposed to consolidate all the discrimination laws and introduce the Parliamentary Joint Committee on Human Rights and statements of compatibility with new pieces of legislation and a National Action Plan on Human Rights and a few other things. And then that kind of fell into disuse fairly quickly as a framework, wasn't sort of supported by the change of government when the Abbott government was elected, and we haven't had a human rights framework since. And the view of the commission, which we've put in our submission to the Parliamentary Joint Committee on Human Rights, is that the level of protection of human rights federally isn't sufficient, and that the absence of a sort of a national human rights framework to sort of enable government to prioritise human rights and to be held accountable for human rights is not sufficient. And so we do think that there should be a new human rights framework, and this slide that's on the screen talks to what we see as those sort of key objectives of having a national human rights framework, which is essentially that there's a process by which government can set national priorities for the protection of human rights, where you can be measuring the progress against that in an independent way, where there's dedicated and focused education of the community about their rights, there's full protection of human rights in law, policy and practice, and there's the transparency around decision making as it impacts on human rights. So what we've done in the inquiry to date is we've set out the 5 key elements, 5 pillars of a human rights framework, and 3 foundations that sit alongside that. So essentially 8 sets of measures. And I think a number of these will be particular interest to QCOS and its members. So the first one is, ensure that there is comprehensive and effective protection of human rights through a National Human Rights Act, as we've talked about today. The second one is the modernisation of federal discrimination law. We put out a position paper similar to the one on the Human Rights Act that looked at federal discrimination law about 18 months to 2 years ago now. And the concern we have with federal discrimination law is that what you've had a Racial Discrimination Act introduced in the 70s, sex discrimination in the 80s, disability in the 90s, age in the 2000s, some protected attributes on LGBTI issues in the 2010s. And all of it's just kind of just added on top of whatever's there existing. And so now you have different definitions of what is discrimination across each of those different pieces of legislation. If you're a small business, sometimes some of the provisions apply to you and sometimes they don't, depending on what the different act says. There's, in one act you can apply for an exemption, in another you can't. It's a little bit incoherent, and over time it's just become a bit of a mess. And alongside that, what you've had other sort of fairly major reforms to regulation that have occurred across different areas, whether it's around consumer law or privacy or securities and company law, etc. And in particular, you had this legislation in the 2010s under the Abbott government called the Regulatory Powers Act. And the view of that was that, there shouldn't be 200 separate forms of regulatory enforcement powers across the Commonwealth. There should be, as much as possible, a standard set of powers that regulators have. And then what this Regulatory Powers Act does is, for different regulators, they have the powers in Schedule 1 of the Act and Schedule 3 and Schedule 5, depending on what their role and their functions are. So there's been this kind of world of reform of regulatory powers that's been applied across most areas of federal law, but it has not been applied to discrimination law. And so the powers that exist in federal discrimination law are as they were in 1985 when the Human Rights Commission was put into a permanent footing, or 1986, I should say. So we're saying this is, it's a completely out of date system of protection. It's not as effective as it should be, and it requires significant updating and modernisation. And so that position paper sets out a very comprehensive approach to how that happens. And so we see that as the second key pillar of a national human rights framework. The third pillar that we describe is around enhancing the role of Parliament in protecting human rights. So part of this is around statements of compatibility and the role of the Parliamentary Joint Committee on Human Rights as the scrutiny body that will give advice to Parliament on whether laws that are proposed meet human rights standards or minimally intrude on human rights. But what we also think is that there's a disconnect between the international scrutiny processes that apply to Australia through human rights treaties and how they're treated in a domestic setting. So in particular, every 5 years or so, there'll be a review of Australia's progress under each of the human rights treaties. They issue concluding observations, and then nothing happens pretty much. The government, the Attorney General's Department, will load the concluding observations up on their website, but that's about it. We're saying that, they should table those concluding observations in Parliament. They should make a statement to the Parliament about what actions they're going to take to meet the human rights concerns around compliance with the treaty, and that the Parliamentary Joint Committee should have a role in, convening an inquiry into the adequacy of that response, for example. So you formally bring Parliament into the loop of that international scrutiny to ensure that the government is sufficiently acting to address concerns that are coming out of it. We also think that should happen in relation to individual communications. So an individual communication is essentially a complaint that you can take to one of the international human rights treaty committees. And you can only take it to an international treaty committee if you've exhausted your domestic remedies in Australia. So you've been to the Commission, you've been to the court, however processes work. What's happening with those cases that go to the UN is there's often findings made against Australia in relation to immigration, for example, and they're unaddressed. Most recently, interesting cases brought about Australia's inaction on dealing with climate change. It's been one that was brought by a Torres Strait Islander community. And perhaps more notoriously, there's been a number of complaints brought about from Aboriginal men who have been, essentially, they've been unfit to plead in criminal proceedings because of the mental disability that they have. And so they are detained in prisons indefinitely. And over time, some of these men continue to be in prison today. If they'd been charged, they'd been found fit to plead, they'd have been charged, they'd have served the sentence, they'd been out of the community years ago. So you have communications going through the UN system saying this is unacceptable, and you don't have a resolution to those issues happening. So again, the responsiveness to into individual communications, we're saying probably needs a stronger parliamentary oversight, because the current system, where there isn't that oversight, is resulting in inaction, in human rights breaches that have been identified not being addressed. So the third pillar is that enhancement of the role of Parliament in protecting human rights as part of that accountability and transparency piece. The fourth pillar, I think, will be of particular interest to QCOS, not the others aren't, and it's one that I'm particularly excited about, and this is that there should be a national human rights indicator index. So what we're saying is that we don't measure progress on how we meet our human rights obligations sufficiently, and that what we ought to have is the national human rights indicator framework that can answer the question of how well are we doing in protecting people's rights. We take a lot of inspiration here from models in New Zealand and the UK and other places. And the UK model is called Is Britain Fairer? And so it's an integrated framework of indicators that apply across all areas of public life to ensure that any person in the community has essentially the opportunity to have an equal life chance as anyone else in the community. And then it's measured across different protected attributes and, age, race, disability, other statuses as well. So you can see where there are gaps in protection, who's falling behind, who's not getting the same opportunity, and that sort of thing. We think this is fundamental and it's missing from the Australian system. And we also think it's the sort of thing that would probably be done by an agency like the Human Rights Commission, which makes it arm's length from government as well, because a lot of what happened under the human rights framework in the past is that there were all actions that were going to be taken by government. And the moment that the new government comes in and says, we're not interested in that, they all just fell in a heap. So it didn't have these sort of more independent processes that can continue on and to provide that sort of benchmark for the community and for government that's less easy to just get rid of when it's convenient to do so. So a national indicator framework, we think, is a critical missing element, and would be critical in ensuring the appropriate protection of economic, social and cultural rights, because you would anticipate that a number of those indicators would be around adequate housing and health status and access to education and various other things like that. It would also have to cover civil and political rights and somehow have to benchmark how protections of freedom of expression and opinion and so forth are being protected in Australia, and whether they're regressing or advancing and so forth. And then the fifth pillar is, and we've described here as an annual human rights statement to Parliament, which sounds a bit smaller than the other ideas in a sense that are on the screen there. But essentially in the past, you've had a National Action Plan on Human Rights, and national action plans have tended to be a collation of different actions that are occurring across government, but they've tended to not have a lot of action in them or funding behind them. They've tended to not reflect new commitments or anything like that. And so we're kind of stepping away from saying that there should be a new national action plan on human rights and sort of simplifying it and saying an approach that is more akin to what happens with Close the Gap at the moment, the Closing the Gap process, which is the Prime Minister gets up once a year in Parliament, releases a report on how Australia's tracking and meeting its closing the gap obligations and setting out what the future actions will be. Now, that's not a perfect process, and we know that, but we think, you know, government should have some sort of process by which it will annually say, these are the key human rights priorities nationally that we are facing, and these are the actions we are taking. This is what we've done to address actions that we've previously identified, etc. So it's intended to be a fairly light touch, but as a way of bringing a conversation to the fore at the national level that human rights are important, that they're worth protecting, and that the government is actively making decisions about what it's going to do to protect human rights, which is something that we would say is not happening now. The three foundations, I won't talk to them particularly. They're probably pretty obvious, but one of them is human rights education and comprehensive human rights education across the community. One is a sustainable human rights commission. That's both in terms of the breadth of our functions and the resourcing to be able to do that. And then the final one is support for a vibrant civil society to protect human rights. Now, in that element, we've put a number of suggestions in the submission as to what that covers, but I think this is one particularly for community organisations that would be great for the committee to hear views on what sort of supports ought to be provided, what sort of recognition ought to be provided to the community sector for its role in protecting human rights. We've done, I think, very much a starter list of the types of issues that would sit within that, but I think there'll be a range of other issues that could be there as well, because ultimately we're saying, you know, while the primary responsibility for protection of human rights is a government responsibility, it actually takes action and partnership across the entire community to achieve that, and recognising the role that different sectors play is critical in doing that as well. So that's what we've proposed to this committee. Where they're at is they're accepting submissions through to about the 30th of June this year. They are likely to then do public hearings across the nation, and, you know, they'll certainly, I would have thought, do Brisbane and, you know, capital public hearings, probably July, August, possibly into September. And then they're due to report to Parliament in March next year. And our hope is they will recommend that there should be a national human rights framework, that it would contain these elements that are here on the screen, and in particular that it would recommend that the time has come for a Human Rights Act federally. So yes, Stacey, I'll stop there. I'll take the screen off as well.
Thank you very much. Some great, a really great overview and thorough overview, Darren. Really appreciate that. And this is really the point in which we're really hoping that organisations in Queensland will ensure their views are heard. And Lauren from our policy team has prepared a few questions that we would like to pose to the group regarding the inquiry and the views that we will be representing through our own submission. So there was a poll that I think a few of you saw a sneak peek of before that we'll put up. And then we have a couple of questions for you to respond to via the chat. If you'd prefer to, really happy for you to also email us with your thoughts. Some of you might want to, you know, think on this for a little longer, but we'd love to get your thoughts via the poll and the questions. So Lauren, if you just go from press from beginning, your slide should go up in their full.
Sure, and sorry for my, this is the first time I've done this.
It's okay.
Is that working?
Yeah, that's exactly right. That's right. So we've got the poll at the moment with the first question, which is, should Australia have a Human Rights Act? You can just indicate on the screen what your answer is for that. And then our other questions are more qualitative. So we'll get your thoughts via the chat if you're comfortable with that. I'll leave you in Lauren's capable hands. Thank you, Lauren. And thanks very much, Darren.
Thank you, Stacey. So I'll just flag that you're all very welcome and very encouraged to reach out to us over the coming month with your feedback ahead of the inquiry.
we're really keen to ensure that our submission is representative of the sector and representative of your views. And along those lines, we'd also really encourage you to think about how you might like to engage with this inquiry. We're going to be holding another meeting in a couple of weeks for anyone who wishes to sort of further discuss the submission process and how you can add your voice to this really, really important moment in time. I think our poll has closed. I might move on to some of our other qualitative questions. Completely understandable if you're not ready to have a response to these questions just yet. You can always write to us later or reach out. And if you do feel comfortable posting an answer in the chat, please do. So the next question we had was, what are some of the reasons you think Australia should have a Human Rights Act? So I suppose reflecting upon some of Darren's presentation today, or perhaps reflecting on your own experiences or the experiences of the clients you assist. It can be a big question, so I completely appreciate if I'm putting you all too much on the spot. And similarly, if anyone would like to speak to the group on any of this, please just use the raise hand function. You can see we have protection of people in the chat, which is a really good fundamental response. While you're all thinking about some of the reasons why you think Australia should have a Human Rights Act, I'll also just take the opportunity to thank Darren for his wonderful presentation today. We really appreciate the time you've made available for us.
Maybe I can add to that as well, just to highlight, if people are wanting to look at it, there's a really wonderful report that's been done by the Human Rights Law Centre. It's called 101 Cases, How Charters of Human Rights Make Our Lives Better. And that's really good at using examples across the ACT, Victoria and Queensland, as well as internationally, of how the Human Rights Acts have improved situations. And in our position paper, we've also put a whole lot of practical examples of how it makes a difference in aged care and immigration and housing and a whole lot of other things as well.
Thank you, Darren. So another question we've been reflecting on, what do you think can be learned, adopted or strengthened based on the Queensland experience of having a Human Rights Act? And I think we could, potentially go back to Joshua's question here, where perhaps we could look at that override declaration process and how it operates in Queensland, and whether there might be a similar process at the federal level and how that could be defined in a good way. We also have the Queensland Human Rights Act review coming up later this year. So these are all good questions to think about in terms of this federal space as well as the local space. Queenslanders are in a really unique position to be able to comment on how some of those complaints mechanisms work under our own Act, and what we can learn from our own experiences here. And I think some of the position paper from the Australian Human Rights Centre also draws upon the experiences of the ACT in Victoria and Queensland, which is really, really helpful. I think I guess the last question we had, and this is probably a good question for follow up later on. But if you do have any examples or stories that you'd like to share with us, any kinds of case studies that might help paint a picture on why a Human Rights Act at the federal level would be helpful, just really encourage you to share that with us if possible. With that, I might actually just open up the floor to general questions for Darren again, now that we've all had a little bit of time to reflect on his presentation. So I might stop sharing. I'll just confirm my screen isn't visible anymore.
Yep, it's gone.
Right. So I might just perhaps I'll start by inviting Darren to share any further comments you'd like to raise, and I'll keep an eye out in the chat function for any questions, but you're also welcome to raise your hand as we go forward.
Yeah, not a lot for me to add at the moment. I'd be interested to hear if there are things people want to hear from. I guess the only thing I'd emphasise is I think it's a really important moment that we've got now. We haven't had this opportunity to have a serious consideration of a Federal Human Rights Act since 2009, 2010. And the sense I have too is that the context has changed in which this debate's happening as well. And there's a few submissions that are already up on the PJCHR's site for this inquiry, but one of them's interesting. Is from a religious organisation that, if I'm correct, and I think I am, I think they were opposed to the Human Rights Act back the last time round in 2010. And this time round, they say, look, with all the things that have happened in recent years and with COVID and other things, we need a Human Rights Act and we need this protection, and they're supporting it on this occasion. And people like Bob Carr, who was very significant in sort of undermining the Human Rights Act last time round and was quite opposed to it, has said he wouldn't oppose it this time round. So a lot of people who've been opponents of the Human Rights Act in the past, it seems that things like the COVID situation and how human rights were treated in that has shifted their mindset. So it's a very significant moment, and we haven't had a moment with this level of opportunity for a decade. So a decade plus. So it's really important that if people are supportive of the Human Rights Act, that they make their voices known on this, because we may well get there this time. After first attempt to get one was the 1980s, so it's 45 years of trying.
So I can see we have a hand raised from Adam. Adam, would you like to ask your question?
Thanks, Lauren. Thanks, QCOS, and thanks very much, Darren, for that explanation. I have to apologise. I was late, and you might have addressed this at the beginning, so if that's the case, sorry. Just had a question about the right to a healthy environment. I see that the position paper refers to the two covenants in terms of the development of the language, but could you just elaborate a little bit on how you arrived at the formulation?
Yeah, sure. It's I'm just going to see if I've got some extra material here that I can refer to. The full position paper, which is a good 400 plus pages long, has a lot of more detailed information in it. So there'll be some material in that'll be worth having a look at. But in essence, I mean, there's now general comment by the Committee on the Rights of the Child in particular around climate change and how it relates to human rights. And there are already explicit references to sort of right to healthy environment that exist in the right to health, for example, under ISESCA. So what we've done particularly is draw out specific treaty obligations as they're in the covenants and the Convention on the Rights of the Child in particular, and then articulated them separately in a standalone right, rather than them being kind of buried under a right to health, and then you interpret it with the Convention of the Rights of the Child and that type of thing. So it's kind of been a bit of comparative look through the various treaties and those sort of provisions. So yeah, there's more detail in the paper as to the exact formulation that we've proposed, but we've stuck very closely to wording of the treaty and to what we think is very established interpretation from the treaty bodies, and that's obviously to an issue of constitutionality to do that as well, because we'd be relying on 51(26) of the 29 of the external affairs power of the Constitution for validity for this as well. So we've been reasonably conservative in how we've framed the right based on that as well. There's a very good report by the ACT Environmental Defenders Office on the right to healthy environment as well, that I think is having a lot of influence in the ACT. They're about to introduce the right to healthy environment into the ACT Charter. It's on the legislative program for the next couple of months.
I can see another hand up. Oh, sorry. Sorry, Adam. Did you have any other questions, Adam, or should I hand it over to Marion?
No, I was just saying thank you. Cheers.
Thanks, Lauren, and thanks, Darren, for the great talk. It was incredibly helpful. So I am a supporter of introducing the Australian Human Rights Act. I need to preface that because my question is, in your environmental scanning and knowledge of the Australian and international scene, have you come across any unintended consequences of introducing a Human Rights Act that we need to be wary of? Or do you know enough about it now to be able to avoid those, I guess?
Yeah, it's a really good question. I think what we've done in developing this is we've looked very closely at the models that have existed across the globe, and particularly in Commonwealth countries, New Zealand, and the UK, as well as Victoria, Queensland, the ACT, and it very much builds on the lessons that have come from those different models. So and what's been interesting as we've kind of been doing briefing, we did a lot of consultation in the development, but now that we've finalised the model and we're doing briefings with a variety of people, and the Queensland Commission, the ACT Commission, and the Victorian Commission have all said, you've really addressed the challenges we have in our models, and we're going to pick up what you've got and advocate for it in our models and with our reviews. So no, I think often the unintended consequences, I think, are going to come, that there'll be interpretations of the charter that will, in some instances, will expand protection in ways that people just wouldn't have thought about at the time. Like I think if you'd gone back 20 years ago in terms of how do you protect LGBTI rights, then people would not necessarily have seen a right to privacy as being the key right in relation to that, for example, and it's proved quite critical in a whole range of different ways in anchoring those rights. So I think a lot of the unintended consequences will be people will be imaginative and they'll find ways to get extra protections, to be honest. The risk will always be, I think the risk federally is probably where the courts are involved in this and how they interpret rights. There's been, some problems in the discrimination law space where there's been some just really poor judgments in the federal court, in particular, occasionally in the High Court, that offer a very limited interpretation that's caused real problems under Disability Discrimination Act in terms of reasonable adjustments and what they are, and in the Indigenous and race space around what a special measure is under the Racial Discrimination Act. But look, I think the model here is calibrated to be consistent with the international law understanding, and often where the courts have been getting it wrong, in my humble opinion, is that they kind of stick to a more domesticated interpretation of provisions, and that gets out of whack with the international jurisprudence, and which is another problem with the discrimination laws. I think, you know, some of the provisions are just interpreted, you know, they're 10 years out of date in terms of how they're being interpreted. So there's always that risk. But I think we're fairly confident that the way we've designed the limitations clause and the interpretive clauses are best practice, and they build on the experience of what we know so far.
Thank you.
No worries.
Did anyone else have any other questions in the last few minutes of today's session? In that case, I might just share my screen again, hopefully with a little bit more grace. So I'll first just say a really big thank you to the Human Rights Commission for joining us today. We've really appreciated the time you've dedicated to helping us understand how we can engage in this really important reform. There is a small poll up at the moment, just in terms of how you found this workshop. Your feedback is really helpful for us, so please do respond if you have time. We will also have a meeting on the 21st of June, which you'll all receive an invitation to, just especially for anyone who's thinking about responding to the inquiry and writing a submission and could benefit from perhaps talking that through a little bit further with QCOS. I should flag that was just a meeting with QCOS. Please keep an eye out on your inbox. There'll be an email from us soon with a few resources and links that you might find helpful. You'll also see some of those questions that we raised. If you'd like to reflect on those and send any feedback along to the research inbox, please do. And I think that's it from us. A big thank you to Stacey as well, who had to leave a little bit early, and thanks again to the Commission for being here and for supporting our members to engage with this work.